that being failure to comply with the order or signal of a police officer, a felony of the 3rd degree. Your Honor accepted the plea and ordered that the defendant undergo evaluation, specifically a PSR, as well as a drug and alcohol evaluation. We have read the report. The state is ready for sentencing. It should be noted, Your Honor, that there is no prior agreement as to sentencing. Finally, it appears that the defendant has 117 days of jail time served to date. Thank you.
Ms. Tomaszek?
Yes, thank you, Your Honor. We're prepared to proceed with sentencing today, and we did want to request, in lieu of prison time, to allow Mr. Watkins to go to NEOAP. Mr. Watkins does have a criminal history. Half of his criminal history is drug-related. He's indicated to me he definitely does have substance abuse issues. He's never received treatment in the past. He has gone to prison. He still was continuing to use drugs, so I do think treatment would be greatly beneficial to him. I do think Mr. Watkins indicated to me he does have a daughter. She's going to be 2. He has missed, the past 4 months of milestones of her life. He wants to be there for her. He wants to be sober for her, and he wants to get that help that he needs. He was gainfully employed prior to this. He was working at Campu Roofing. He did leave on good terms to open his own mobile detailing business, but he did indicate to me that because he left on good terms, he can go back to Campu Roofing at any point to keep himself busy. So I do believe with working, doing treatment, getting help, he will definitely keep busy to stay out of trouble and be there to raise his daughter. He did also, his girlfriend is here. I did have a chance to speak with her as well. She did describe Mr. Watkins as a great father and a good, hardworking man. And I do believe he'll greatly benefit from treatment. It does look like he does have some trauma from being shot times back in 2011. So Mr. Watkins does believe that could be an underlying issue that he does need to get resolved. He's never actively gone for mental health treatment before, but he's willing to do that to help with the underlying issues of possible drug use. Thank you.
Thank you. Mr. Watkins, what do you want to tell me before I impose my sentence?
Yes, good afternoon, Your Honor. I would like the court to know that I am sorry for my actions. And I'm also thankful that I didn't hurt anybody during the course of my actions. And I do understand that there's no excuse whatsoever for my actions. But I also believe, like, everything happens for a reason. I believe my reason is, like, this is, like, a rude awakening for me because it could have been way worse. Like, this is pretty bad, but it can also be way worse. I could be looking at a lot more time. I could also not be here. I could really hurt somebody. So for that, I am thankful and grateful. And that's pretty much it, Your Honor.
Mr. Tavanche.
Yes, Your Honor. It's the state's position that probation would not be appropriate in this matter. The defendant does have an extensive criminal history dating back to his juvenile days. In addition to the serious offenses while a juvenile, he has 6 felonies as an adult, several of them severe. One of them, in fact, being prior failure to comply, which is, of course, what he's being charged or being sentenced for today. He's been to prison 4 times. First time he went to prison is he was given a chance initially for early intervention, but he failed to appear twice and therefore kicked that to the side. He has a consistent history to appear in a long history of warrants. In fact, he has some 3 active warrants now. He has a long history also of misdemeanors involving drugs and a history of convictions for disorderly conduct, criminal trespass, theft. All of this shows that the defendant is either incapable of or unwilling to conform his conduct to what the law requires. I have actually described the egregious nature of the defendant's actions in this case. Last time, Your Honor, I did describe those facts. It was, as you may remember, a speeding violation, lights and sirens, where defendant led Willowick police on a dangerous, circuitous, long-distance, high-speed chase over freeways and over access roads and surface roads. Your Honor, this chase lasted about 15 minutes. That's a long time, given the speeds. Defendant was going 110 miles an hour at one point on a freeway, where the speed limit was 60. On surface streets, he was hitting about 60 or 70 miles per hour. At one point with a blown tire, also with pieces hanging off of his car. He's still going. This chase spanned several cities. It begins in Willowick, ends in Cleveland. I mapped it out. It was a total of over 17 miles. all the time weaving and speeding. It was on the surface roads where he was most dangerous. He runs 6 stop signs by my count, 3 red lights, just blows through them. Luckily, most of the lights were in his favor that night. Most of them were green. It was late at night. And I say luckily because it doesn't appear that he really cared to stop for any light. He nearly misses the car coming. He just eats a light, nearly misses a car coming across on a green legally. While he's on surface streets, he also goes dark. He turns off all his lights. It's dark out, as I mentioned, and therefore he's required to use his lights, but instead he turns them all off and seems like he's trying to get away. Meanwhile, he's swerving. In at least 3 instances, he purposely weaves into oncoming traffic where there's a car coming toward him, and in the minds of the officers, they believe he was trying to hit them. At the very least, it seems maybe he was trying to get the officers to believe this was not worth the chase because of how dangerous it became. He rides into the oncoming lanes, not even swerving. He just rides into the oncoming lanes, sometimes for maybe a quarter mile or so, although it's as though it were simply a thoroughfare for him. Goes down a wrong-way street on a one-way. The pursuit ends only because he destroys someone's property. He runs his vehicle into a fence. It's owned by a local school. We have no victim's impact statement, but the damage is heavy. In the video, you can see that fence just go down. And it doesn't end there. When his car's finally stopped, he bolts from the car, and he runs, and of course, officers have to catch up with him, and he still resists, and he must be tased for his compliance. Now, all of this shows really blatant disregard for the safety of others. This also shows it's in line with his criminal history, including failure to appear time and time again, not conforming his behavior, his history of drug abuse, which we know he has. In fact, he admits using Percocet and cocaine on top of alcohol that day. And as far as his PSR is concerned, he doesn't seem to show a lot of remorse. He seems to have a nonchalant attitude toward it. And when probation asks him what he's looking for from this hearing, he basically shrugs his shoulders. For those reasons, we believe that prison is warranted. That is all, Your Honor.
All right. Anything else from the defense?
Yes, sorry, just one more thing, Your Honor. Of course, there's no excuse for Mr. Watkins' actions, but I do just want to reiterate that I do believe drugs is a huge issue for Mr. Watkins. As the state put on, he was high at the time of this incident. Of course, no excuse, but I do think he would greatly benefit from NEOAP and getting that help that he needs for his addiction issues.
All right, I've reviewed this pre-sentence report and this drug and alcohol evaluation, and obviously there's a drug and alcohol problem, but there's been a drug and alcohol problem for now, and there's been no effort to address it. The fact that you were under the influence, I don't know if that's why you ran or if that's just your inclination, but the fact that you were under the influence doesn't, makes it, in my mind, a little bit more serious. Because in these kind of cases, and more specifically in this case, the general thought is that if you go fast enough, they're going to cut off their chase for public safety reasons. So the speed that he clocked you at was 80 as you're going east on 2. You bring the car to a stop around the Vine Street exit, and then after he gets out, you see your opportunity, you get off, you get back on, you head west through Willowick again, through Wickliffe, through Euclid into Cleveland, which generally is where these chases end. If they can't get a car before you leave the county and Euclid can't get you, then they're just going to quit, especially when you're going 110 miles an hour. They're certainly going to quit. Usually when they get to 80, they quit. Okay, you were well above that, and an immense amount of danger on these side streets once you get off the freeway, almost hitting that car coming the other way on Nottingham, crossing traffic. So you had no regard for anybody but yourself for the purpose of getting away when you were driving. And that presents, I mean, this is one of the more extreme cases of a danger to the public by somebody in these flee and elude cases. And you're no stranger to them because you just had one that you went to prison for. I think in 18 or 19. And remind me, Mr. Tavanchi, was he on post-release control for that?
Actually, I do not have a note on that, Your Honor. I apologize.
So you were released in November 19th, or no, July 31st of 21. If you were on post-release control, presumably you still would have been on, but I don't know, one way or another. So you're not that far removed from when you committed this offense in June of 24. I don't know what, if anything, is going on with the felonious assault case that's listed in Cuyahoga from October of 23, or the obstruction in East Cleveland from April of 23, but things just don't seem to change, even when you get the severe penalty of going to prison. So as I said, this is one of the more extreme cases of the failure to comply that's come across at least my desk in my time here. In addition to that, last time you were to prison, you were there in 16 and 17, 10 and 11. So you haven't curtailed your behavior whatsoever. And the fact that you have a drug problem is not an excuse. It's not a free pass to commit crimes and then blame your drug addiction. You have the ability to do something about it, and you didn't address it. So I'm going to, in consideration of these reports, in consideration of your statement, counsel's statement, and considering all the factors in 29, 29, 11, the purposes in 29, 29, 11, the factors in 12 and 13, I'm going to find you're not amenable to community control. And on this offense, I'm going to sentence you to 24 months in prison with credit for 117 days, and the costs are assessed. When you get out, you will be on post-release control for at least 1 year up to 3 years under the parole authority. They will place conditions on you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If your violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months or the time you have left under post-release control. There is a mandatory lifetime operator's license suspension. Is there anything else, Mr. Tavanchi?
Yes, Your Honor. At the time that this happened, the officers found in the defendant's car some items. For example, just give me one moment. Some 30 grams of weed. We would ask for that to be forfeited. And another set of items which we would be returning, those are 2 sets of car keys, 2 license plates, an Apple iPhone, and a car title to a 2000 Oldsmobile Intrigue. All of that we don't need to hold on to, but the 30 grams of weed we would ask for a forfeiture.
All right, the drugs will be forfeited. The rest of the items will be returned. Anything else, Ms. Tomazik?